Before I start, let me, share the screen with you. Komal, if you can confirm if you're able to see the screen. Okay. I hope my screen is visible to all the participants. And so this is a topic which is technically, uh, you know, in a sense, very common for people who are coming back to India. As people say that, there was a time in, I would say, roughly 90s and early, part of the millennium, early part of this century, that, there was lot of interest, or even today there is, for people to immigrate outside or move outside India. Of course, for better education, for better job prospects, and for better business opportunities. In last, I would say 2 decades, it's seen that, and especially in last 5 years or 10 years, we have seen a lot of people coming back to India, which are popularly known as returning Indians. Someone was telling me that it's kind of a ghar wapsi. I said yes, because of the kind of the opportunities which India today provides, and of course for various other reasons. If someone wants to retire, or if someone wants to come back and do something for the nation, being a Indian citizen, and otherwise so also for even for the PIOs, which are known as person of Indian origins, who are always born and brought up outside India, but would like to make their careers, or for some or the other matter, the way the India is going in last couple of decades, it provides a lot of opportunities in various fields, being a nation where the demographics are in favor of the growth. With this, I think this is a reason why today you see many of even my friends and many of our clients who comes to us that we would like to move back to India. But before moving back to India, we need to understand what happens with respect to our assets, our incomes overseas India, outside India. Because one of the major factors which distinguishes India with other countries is the foreign exchange regulations which are there in India. Not likely, you will see such regulations anywhere in the foreign countries, especially the developed countries. There are a couple of developing countries, especially South Africa, which also has a good amount of stringent foreign exchange regulations. But India is a country where foreign capital is always been, you know, asked for, or aspired for, and hence we have a very stringent foreign exchange regulations from last many decades. However, in around 25 years back, the whole landscape of foreign exchange regulations went undergo a very significant change. I would say the landscape moved from regulation to management. As it says, it was earlier Foreign Exchange Regulation Act, and now it is Foreign Exchange Management Act. It's far more liberalized, far more rationalized. And in terms of the way the transactions are evolving, it is far more accommodating also. However, still, it is in terms of, if you compare to any of the developed countries like US, UK, or any other countries in Middle East like UAE, it is not fully freely. You can't do all transactions freely in foreign exchange as you could do in these countries. That's why it's very important for all the NRIs or PIOs who would like to come back to India for good, to first understand how it implicates their assets, how it affects their income, which might continue even after coming back to India. And that's the reason we are having this session. Of course, it's a 1 hour session. We'll try to cover as much as possible, including couple of case studies. But the rationale is that only that today there is a lot of questions which are asked when the people are returning back to India. Directly jumping to the contents of today's webinar, we are going to cover it into 6 small capsules or parts, you can say, or topics. One is to understand the residential status under FEMA. Who are immigrants and who are returning Indians? What are special provisions for them? What are the permitted and restricted transactions under FEMA after you become a resident individual? What are the bank accounts and repatriation facilities available for them? And what are the do's and don'ts which one needs to be, careful of or keep in mind before relocating to India? These are the 6 topics which we are going to touch. There is a cardinal rule under FEMA which I think I would spell out first before dwelling into the topics which we discussed, is that FEMA is by far intention based act. It is not similar to Income Tax Act, which I think if there are chartered accountants or professionals who practice into tax would largely know that it is driven by law, it's driven by a code. Even if it doesn't sound rational to you, even if it is not intended, but if you contravene the law or if you fulfill the law, you are by far regulated in terms, and the judges, the courts will held in your favor or against you based on the pure reading of the law. However, under FEMA, it is more intention based. And why this is more important to understand when we are dealing with residential status is because when you read the plain vanilla definition of residential status under FEMA, you might find it very novel because it starts with something as a very primary condition of stay more than 182 days in the preceding financial year. But then there comes a negative that it does not include 1, 2, 3. Okay. So this is the reason why it is very important to understand the definition along with the intention and not the pure reading of the conditions. What it says, person resident in India means the person who is residing in India for more than 182 days in the course of the preceding financial year and not the financial year in which you are considering the residential status. So if you are considering the residential status for financial year, which we normally understand as April to March, let's say 24-25, you have to see the number of days in 23-24 to see this primary condition. However, this primary condition gets negated if you have gone outside India for employment, if you've gone outside India for vocation or business, or for any other purpose which indicates your intention to stay outside India for uncertain period. The same applies in reverse, which is very applicable for today's topic. That if there is a person who has always been a resident outside India, who has never come to India from last 10 years, has come to India for either employment, for doing any business, or for an intention where he or she would like to stay in India for an uncertain period. Why I say this third condition is very, very important. There are many people who have come across who comes to India for their retirement life, who comes to India for something beyond employment or business or vocation, right? In that sense also, you can't wait for the year to complete 182 days before you become a resident in the family. The way it is being explained under the section, it gives you it's an enabling provision so that if you come to India with a mindset of being in India for an uncertain period, you should be considered as a resident, and that will enable you to open the normal bank accounts which is needed for day-to-day transactions. If you go strictly by the condition of 182 days, you will never fulfill that condition if you have been outside India for years and you move to India. Suppose you move to India in April 25 for good. You will never be a resident if you only go by the primary condition for 25-26. Because you have never spent more than 182 days in India in 24. That's the reason one needs to understand that it is beyond the days, it is more of intention based. And another important thing is FEMA has something called split residency concept. So suppose there is a person who comes to India on 1st of March 2025. He comes for employment. He will be resident from 1st March 25 if he has an intention of staying in India or on an employment and converts is so this is the intention. Now, how you convert your intention in documentary evidence is you when you open your normal bank accounts or convert your NRO NRE accounts to resident accounts. Suppose you convert your NRO NRE accounts to resident accounts, right? For 1st March 2025. In the same financial year, for first 11 months, you'll be considered as a non-resident. But for the month of March, you will become a resident of India under FEMA. And why this is important to understand? Because under FEMA, FEMA regulates transactions. FEMA is not here to ascertain your income or ascertain any liability to be paid to the government of India. It is more of restrictions, permissions, and prohibitions on what kind of transactions one can undertake as a resident in India and as a person resident outside India. We are not going to go much in detail with point 3, which is mainly applicable to corporates and other entities, because we are right now on the topic of returning Indians, which are individuals. PROI is defined as a very simple, the person who is not a resident in India is considered as a person resident outside. Please feel free to ask any questions and post that in Q&A box. I would be more than happy to take it at an appropriate time or at the end of the session. Now, as we discussed, it's an intention-based definition. Documentary evidence like visas, other travel and employment records are very, very important to prove the intention. Just by saying that, okay, I intend to stay in India. But what if you don't have the visa? What if you don't have the permission? What if you don't have the permit? What if you don't have the reason to prove your intention of staying in India for an uncertain period? Then that doesn't help you to convert your bank accounts or to prove your residential status under FEMA. Secondly, as I told, FEMA residential status is far, far different when you compare with income tax. Income tax, there is no concept of split residency. Income tax is purely on the days of stay in that financial year. Of course, with conditions with the past financial years for resident and non-ordinary resident and resident and ordinary resident definitions. Let's take a very simple example. Mr. Amit was an Indian citizen and resident of India till June 2024. He moved to US for a job on 1st July 2024. He stayed there till 5th of November 2024 and then visited India for his marriage. However, since he was about to get married, he came for early preparations and he stayed in India for more than almost 5 months or 6 months because he was in India for April 10, 2025. Or he's planning to be in India for April 10, 2025. And will be working from India and for his job in US. His wife is already a US citizen and born in US. She has just come to India for marriage. What is the residential status of Amit and Shalini? Now, if anyone who has even doesn't know FEMA would purely say that Shalini is very easy because she was born in US, she was a US citizen, and she has come to India only for marriage. Let me tell you where you are born, who's your citizen, doesn't come into picture if you are looking at a residential status on intention base, because it might so happen that even if you are a resident of US, if you are coming to India for a certain period, you will be again become a resident under India, FEMA in India. There are many US citizens whom I know who are in India but still hold a US passport. Now, when Shalini moves to India for marriage, if her intention is not clear to stay in India, or in this case, because Amit was already having a job in US, the intention was only for a certain period of marriage, hence she would never be considered as a person resident in India. If that would have been the case that Amit was always an Indian resident, even if she would have been a US citizen, and Amit might explore to go outside India, For the initial period, till there is a decision of Amit moving outside India with Shalini, she might become a resident in India because of her intention to stay for uncertain period after marriage. Of course, that's not the case in this case. Here, the intention is very clear. Amit itself is in India for a certain period till April 10, 2025. However, if you see the intention is because he has an employment outside, you would not see while you are asserting the residential status for 25-26, the residential status will not be seen on the days of stay spent in India in 24-25. When Amit moved US in July 24, he would have definitely, or he should have definitely converted his accounts from residence to non-residence, NRO accounts. And though coming for India for reasonable period of 5 months or 6 months for marriage doesn't mean that he has to convert his accounts again to resident and then reconvert to non-resident when he moves outside. In this case, in my opinion, both Amit and Shalini would be resident outside India, even though they have come to India for marriage, even though Amit being spending more than 182 days in financial year 23-24 and even 24-25 for considering the residential status afterwards. I am told my voice is breaking. Komal, can you confirm? Is it so, or am I loud and clear? Okay. I will. Okay. Okay. Now it's clear. Okay. Thanks. So, this was as far as this case study is concerned. Let's move to and this is more of a comparison between FEMA and income tax. A bird's eye view, of course, when the presentation will be shared, it will be more, you can read it in detail. But the bigger difference which I'm trying to tell you is that it doesn't depend upon your days of stay. There's a concept of split residency under FEMA. It is more intention based. Of course, days of stay is a primary condition, but that doesn't mean that it has to be taken as sacrosanct. Because what happens in income tax also there is a leeway that if you move outside India, okay, for employment, and if you spent less than 182 days, you will be counted as a non-resident income tax. But in under income tax act, if you spend more than 182 days in a financial year, even if you move outside for employment, you'll be still be considered as a resident under income tax act. That's not the case under FAM. This is very, very important to understand. And no, I think I will just cover one question. Someone has asked me why Amit would be considered as a why Amit should not be considered as a resident. Amit will not be considered as a resident in the previous case study because he moved to US for employment in July 24, and at that point of time only he become a non-resident of FEMA. Coming to India for marriage doesn't mean that he becomes a resident. He has only come for a certain period. Hence, he will be a non-resident. Now, who are immigrating Indians and who are immigrants and returning Indians? Immigrating Indians are the ones who leave India for employment outside India. And immigrants are the ones who are like person of Indian origins or are foreigners who come to India for good or who come to India for employment or business vocation. And why we say they both are different. Returning Indians means they are the ones who already have Indian citizenship or who are always born in India and now are NRI, okay, and has come back to India for good. So that's the difference between immigrants and returning Indians. Largely the same. You can use either or, but this is a tiny difference, a gray, a thin line of difference between both. However, immigrating Indians are the ones who move outside India, okay, for good, for employment, for vocation, and who become person resident outside India. Whereas returning Indians will become person resident in India. Now let's look about the second case study. Harry Patel was a US citizen, born in India, moved to US. When he was there, he married a person called Clay Murphy. He did his civil engineering master from US and was a successful businessman. He developed many townships and motels in US. However, he always wanted to come back to India. He had many investments in India in shares and mutual funds. He came to India in February 24, started a private limited company with his friend in Ahmedabad, engaged in the business of infrastructure resource. He also became director of the company. He undertook his investments from US. Mind you, again here they are saying that though he came to India for opening up a company, though he became a director, he actually was doing this investment while being in the US. Now, why this is important? When I say it is intention based doesn't mean that just by opening a company or just by coming to India for opening a company, you will become a person resident in India. You also should have an intention to be in India. Just because you become a director of a company, just because you open a private limited company, you own the company, that doesn't mean you are a resident in India. If you still have, stakes in both the countries, you will still go by the intention and the days of stay. In this case, it was clear that till, though it was incorporated in Feb, like any other foreign businessman, he incorporated the business, he became a director, but he still was there in US. In October 24, he redeemed all his investments in India and he made further investment in the company. He moved with his wife and children in January 2025. He bought a house jointly with his wife in February 2025. From which date Harry should be considered resident? See, it is intention based. Just because you redeem your mutual fund doesn't make you a resident. The answer is when he moved to India in January 25, that is the time when he made his intention very clear that he wants to be in India. Though he purchased a house afterwards, that doesn't purchasing a house doesn't mean that your intention was not clear before that. In my opinion, even though a house was purchased in February 25, the intention to move back to India was in Jan 25. Hence, it would be considered under a resident under FEMA from January 25. Now we come to the most important part of this session. I might spend almost more than 15 minutes on this part. The reason being that this is very, very important. That what is available to people who are returning to. First three parts are more of what you are allowed, what you are not allowed. Section 4 prohibits a person resident in India for acquiring otherwise provided income. We will discuss this in detail in the permissible capital and current account transactions. Section 8 governs about the obligation that whatever is due, you should take a reasonable steps to realize and repatriate the foreign exchange within a certain period as prescribed by RBI. We will also discuss a couple of examples in this. Section 9 provides exemption about certain repatriation realization and which is largely governed with a limit of USD 2000. However, the most and most important section which one should look at is section 6.4. Section 6.4 is the backbone of FEMA, section 6.4 and section 6.5 for individuals who move back to India and who move overseas India. 6.4 governs return in India and 6.5 governs immigrating Indians. What 6.4 means? Let's read this together. A person resident in India may hold, own, transfer, invest in foreign currency, foreign security, or any immovable property outside India if such currency, security, property was acquired, held, owned by such person when he was resident outside India or inherited from a person resident outside. Now, let's take an example of Harry only. Harry always had investments in US. Harry always had bank accounts in US. Harry also had immovable property in US. Though he moved back to India in January 2025, is he allowed to continue to hold those assets? The answer is yes, and the enabling provision is section 6.4. Is he allowed to sell these assets? Yes. Is he allowed to use the bank accounts, the money and balances lying in that bank accounts to acquire new assets? The answer is yes. However, once you become person resident in India, you are governed with a lot of restrictions and prohibitions, which is generally not applicable to all your assets which you had acquired when you were person resident outside. Another important part comes is what happens to your inheritance. What happens to the assets which you have inherited from a person who was a resident outside India when you were outside India, okay, or you inherit after becoming person resident in India from a person who was a resident outside. You're allowed to hold, own, transfer, and reinvest all these assets and equivalents by the virtue of Section 6(4). The 6(4) was also given far more, I would say, neat, far more explanation by an APDI circular number 90 dated 9 January 2000. It actually, gave a detailed explanation of what you can do, whether you have to bring the money back from the income which you earn out of those assets. The clarifications does help on this part. It clearly says that all the accounts, all the assets which you held outside India or acquired outside India, when continued after becoming resident in India, if it gives you any kind of income, you are allowed to keep that overseas. You don't need any approval of FEMA to make any investments out of those monies. You are not allowed or obliged to bring that money back to India. You're also allowed to continue all your business, vocation, or in terms of employment which you had outside India. We will discuss about what happens when you receive money through that. We'll discuss that in detail. But this is an enabling provision which is backed by this circular, and it does clarify lot of doubts on the repatriability of the monies which are held outside India or which are earned outside India from the assets which you must have purchased when you were not resident. Let's go upon one of the very, very important part of inheritance. It says that the last phase, if you see, you read that a person is allowed to own, transfer, invest in any currency, security, property which was acquired by such person or inherited from a person who was resident outside India. The problem comes when you inherit. Does that mean that the person who actually bestows the assets on a person who is now a resident in India has to be a non-resident on his death, or was a non-resident, but on death he was a resident, or both is fine? In my opinion, what is looked at is the assets when it was purchased, when it was acquired. The inheritance which a person resident in India receives, whether it is from a person resident outside India or person resident in India, on his death, if the foreign assets which we are looking at was always purchased when that person was a resident outside India, in my opinion, that should not be. Of course, there is someone might interpret that it says that a person has to be a person resident outside India. If you read it very, very literally, inherited from a person of resident outside India means the person has to be a non-resident when he died and when he gives away that to a person resident. In my opinion, it should not be looked at that, because let's take a very simple example. There is a person who is a senior citizen who is 85 90 year old. His son or daughter, okay, is in India. Let's assume there is a daughter who is married to a person in India. The daughter inherits the property from the parents. However, in the last stages of their life, they were not keeping well. And daughter, being the only daughter of that parents, got parents in India for medical for medical, reasons. Also, there was a reason of keeping them with her for a substantial period of time, which gave a uncertain period as a condition, and hence those parents become a resident in India. In such cases, if that person dies, both being resident in India, if you literally you know uh, interpret this, the daughter might have to take a RV approval for inheriting all the property of both the parents outside India, which they acquired when they were residents. Hence, this is very, very important that we need to, and this is what view I have, that you need to be looking at the assets and not the residential status of the person who dies. Some other very, very important portion and issues one need to be very careful of. What happens to movable properties, movable assets like jewelry, paintings, silvers, articles? Because it doesn't get covered under currency securities, immovable property, if you literally mean it. Does it require an approval? In my opinion, the intention is to give a leeway that whatever you acquired outside India, okay, you should be able to keep it outside India. Of if those assets were not out of the money which you remitted outside India when you become a resident. Hence, I don't see any issue in terms of, though very, very clearly it is not covered. But in my view, if it is intention based, the intention is to permit the resident to own all assets outside India, which he or she was owning prior to becoming resident in India. And hence, the continuation of holding those assets, selling those assets should be allowed like any other assets, whether it is currency, securities, or immovable. What happens to interest in LLP partnership firms? Can those be continued? In my opinion, yes. However, it doesn't fall into security. Though, if the assets value are very high, it's always better on a conservativity basis to take an RBI permission. But today, you can't see a act taking into account all the permutations and combinations if that act is more than 2.5 decades old. Section 6(4), in my opinion, it doesn't get changed by an EPDI circular every now and then. It needs an amendment. I understand whenever the FEMA will be overhauled, act, okay, it will be taken care of. But if you go by the intention base, in my opinion, interest in LLP and partnership firms should be able to continue outside India, even after you become resident. A very important case study, or I would say question, what happens to my income which I generate from my consulting or from my employment after I become an Indian resident? Very, very, very important. What happens to my pension? I will go reverse. In my opinion, if you read the circular, if you read the literature, even in FERA, the pension income is being given a special exemption. You can always retain that outside India. You don't need to repatriate that. If you become a resident in India, and if you continue your employment outside India, I would say my view would be that after becoming person resident in India, you are allowed to continue the employment. You are allowed to receive that as a first point of credit in your foreign bank account, but you will be obliged to bring that money back to India. Whether that can be said for the, uh, if you are doing the business through a private limited company, okay, if you're earning any remuneration, one can always say that if I'm allowed to have a business outside India, if I'm allowed to hold the shares outside India, shouldn't I be allowed to have my dividend income and everything? Yes, that all becomes your passive income, and there is a clear understanding. Even the active income is being, if you read the circular very, very clearly, it says that all the income arising out of the employment and everything, you should be allowed to retain that outside India. However, there is a very, very little doubt on what happens to your proprietorship, what happens to the business which you continue from India, which is not in the nature of any other partnership or private limited company or an LLC or an LLP. What happens if you become a if you continue your employment from India on a payroll of a foreign company? Aren't you obliged to bring the salary income to India within the prescribed limit? I would say, though it's clear says clearly, it's always better to bring the direct income of your salary and consulting, which happens in your individual nature to India. Though you can always argue the other way. This doesn't apply, or there is a pure exemption for pension income, there is an exemption to interest, there is an exemption to dividend and all of this passive income. You don't need to bring that back to India. In fact, you can also reinvest that overseas. The same can be argued for this also. However, there is a little ray of doubt, and hence I would say you can always bring this money back to India to allay any other fears of any other, on a conservative basis. Impact on transactions done at the time when you become person, when you were person resident outside India, and now you become person resident in India. What should you do? The ideal case would be you first, of course, foreign accounts you always continue. You should convert all your NRO accounts to NRE, so to your resident savings accounts. Your NRE accounts will also be technically closed because you are not allowed. It will be converted to resident accounts. Technically, what I see banks, they convert your NRO accounts to resident accounts and they close your NRE accounts and transfer the balance into your resident account or convert it to resident account. There is a special, uh, I would say dispensation for FCNR. FCNR can be continued in maturity. Even NRE deposits can be continued. However, of course, it's a tax point, but I would like to bring here. NRE account income is only tax free if you are non-resident under FEMA. Once you become resident under FEMA, even if you continue NRE deposits till maturity, your interest will be taxable. That doesn't apply to FCNR. FCNR interest also remains tax free even after you become resident in India till maturity. Hence, it is very important. Yes, I will come to RFC account. I have covered that in detail. So don't worry about that. RFC account is a special account which is allowed to all the people who are returning Indians. Policies can be continued, no prohibition or permission needed for payment of premium. You should always repatriate your proceeds of your LIC or insurance policy within 7 days of receipt. By the way, I also forgot to tell you one of the most cardinal rule under FEMA is that what you cannot do directly, you cannot do indirectly. You will find this engraved in the whole FEMA regulations, whether it is law, it is different regulations governing fund investment, ODI, ECB, external commercial borrowings is what we say. One needs to be very mindful of that. You cannot bypass. In fact, there is a very clear cut understanding that under FEMA, the capital account transactions, okay, are permissible if they are permitted. If they are prohibited, they are prohibited. If they are neither prohibited nor permitted, you should take it as prohibited for capital account. For current account transactions, in generally they are permitted unless prohibited. This is how you should distinguish. We'll discuss what those transactions are. But I just thought I'll bring out this cardinal rule that what is not permissible under FEMA directly, it should not be done indirectly. Why I'm telling you this? Because there are many ways people try to bypass, do certain transactions which you are not allowed as a resident in India, but you do it in a way which doesn't clearly go against the law as it is written. Okay. Now, what happens to all the investments which you have outside India? What happens to the unlisted shares which you own? What happens to all the private limited companies which you own, or the partnership firm which you own, or the LLCs which you own? Does the overseas investment rules and regulations apply to them? The answer is no. The Foreign Exchange Management Overseas Rules 2022, read with regulations, clearly mentioned that it shall not apply, or it doesn't apply to any acquisition or transfer of any investment outside India, which was made in accordance with 6.4. When it says in accordance with 6.4 means those were made when you were resident outside. Now let's move to the types of transactions under FEMA. What is capital account transactions? What is current account? Capital account transaction doesn't mean all your fixed asset. Don't confuse this with your capital account, which we normally say in the accounting terms. That is fixed assets and everything. Capital account transaction has to be seen from a macro point of view, from the balance of payments of the country point of view. It says that anything which alters the assets and liabilities of the nation, which includes its person's residence in India, whether that is contingent liability, okay, and it also has assets and liabilities in India of a person resident outside. This is where it is clearly says that they are permitted to the extent they are specified. Rest are not permitted, or you might need a prior government or central government or RBI. Current account transactions are different. They are permitted unless they are specifically prohibited. And it can be anything. It can be towards any foreign trade. It can be any income. It can be for remittances, for living expenses, for any foreign travel, education, Medicare, anything. These are the schedules which are applicable under capital account transactions. For returning India, Schedule 1 applies. Once you become a person resident in India, you are allowed to invest in overseas foreign securities. You are allowed to raised foreign currency loans, of course, subject to certain conditions. You are allowed to transfer immovable property outside India, whether it is, acquired under 6.4, or even after you become a resident in India, you are allowed to acquire the property outside India, of course, subject to a limit which is popularly known as LRS, right? So this is very, very important. Of course, maintenance of foreign currency accounts are continued as we discuss. Your life insurance policies also continues, and the schedule 2 discusses about what happens and what is applicable to person resident outside. I have given a detailed schedule 1, 2, 3 of current accounts. One is strictly prohibited. Most of these are like purchase of lottery tickets and everything. Uh, uh, Largely, most of the things are permitted, and you will see a very short list of transactions where there are prohibitions or there is a requirement of prior approval. In general, it is permitted, and let me tell you, all current account transactions, as you see under Schedule 3, are largely governed to an LRS limit, which is popularly known as Liberalized Remittance Scheme, which has a limit of USD $250,000. And let me tell you, this is a blanket limit. And why I say this is very, very important to understand. I've seen many people, confusing this with earlier where there was individual limits. Today, this includes everything, whether it is your remittance towards gifts, it is remittance towards your travel, it is remittance towards your, education expenses or anything, even immigration, right? Even for medical purposes. However, for medical purposes, it is always said that, it is for the treatment overseas India, and with prior approval, you might even be allowed to remit over and above that. However, you are not allowed to remit over and above your $250,000 to take any kind of foreign citizenship or for any points. I have seen many people coming for EB5, largely US residency, which you acquire through green card, and the limit has been increased for 500,000 to 900,000. And with lawyer fees, it becomes $1 million. This is where people try to combine the limits of spouse, use 2 financial years to do that. You cannot do that in 1 financial year. Also, let me tell you that I have seen many people who are very, very, I would say, they get dejected when they go for approval to RBI for higher remittance limit, even though they are earning a lot of financial. The $250,000 limit is always a sacrosanct limit. Very, very rare cases you will be allowed to remit outside India. Why this is very important for returning Indians to understand, and especially in the light when the rupee is weakening, it has gone from 83 to 87. That if you have foreign assets, it is largely very, very I would say smart, unless you need that to keep those assets in dollar terms outside India and not bring that back to India. The reason being is, unless you need, if you bring that money back, it becomes an Indian money. And you will never be able to repatriate back this unless you repatriate under LRS scheme. So let's assume you come back to India, you bring $2 million which you earned outside India, that becomes Indian money. You can't say after 5 years, go to government, ke boss, I was a person resident of India. This $2 million which I brought to India and invested was always the money which I earned India outside India, and hence you allow me a limit over and about to like $50,000. No, will not allow. In a very very rare case, they would be allowed such limits. I personally not come across very many cases. Very, very important. Someone asked me what is RFC account? What is other types of accounts? There are three types of accounts which you are largely allowed to keep after you become personal resident in India, which is known as EEFC account, which is largely uh, opened by people who earn foreign exchange. There is also something called RFD account, which are opened by individuals resident in India. And RFC account are specifically given for returning. If you see this table, which I'm going to share, this PPT, you can always, this is of course there in public domain on RBI site also, that all the accounts has different purposes. All the accounts has different types. If you see first two accounts, they are mostly current accounts. They are mostly non-interest bearing accounts. RFC accounts are not like that. It can even bear interest. However, RFC account, if you see, the permitted credits are largely 6-4, are largely your assets or your exchange which you have realized while you will return back to India. Whereas EFC is mainly your income. RFD account can also be something like that, whether you have received from somewhere or your unspent amount of foreign exchange acquired from AD for trial abroad. So the purpose of all three accounts are very, very different. EFC is largely for exporters. RFC is largely for the people who are returning India, and RFD is largely for people who are residents who are not foreign exchange earners but still want to have a RFD, a foreign currency account. There are permissible debits which you are allowed. EFC is also allowed for any other current or capital account transactions. There are no restrictions on RFC account. That's why it becomes a very, very important account. People who generally come back to India always say that they should always open an RFC account after their accounts are converted from NRO to resident accounts. I think we have covered all the 5 important parts of today's session. Of course, we will be able to look at all the questions if you have anything. Before doing that, let's do a do and don'ts list. Whenever I have clients, individual clients whom I advise, if suppose there's a single call or a single meeting, I always tell them that it's very, very important to understand FEMA before you move to India. There's no point of doing any kind of stuff after you become resident, after you convert your homes. Because then you become handicapped and there are a lot of things which you could have done, you cannot do after becoming a resident of India. What you should do? You should evaluate your foreign investments. You should evaluate your foreign bank accounts. Keep in mind that after you become resident in India, India has a very unique, of course, which is followed by most of the countries now, where you have to report of your foreign assets in your income tax returns. So the more the accounts, the more the investment, the more the immovable properties, the more the compliance burden will happen after you return back to India. I have seen many people who continue to hold that foreign bank accounts with zero balance, but they forget to close that accounts. And then when they come back to India, they don't even report that because they doesn't have, or it might have even a $500 or $1,000 as a balance. You won't believe, I have seen my clients getting notices from the income tax saying that you have foreign blank accounts and you are not disclosed. So please make a checklist as to what you hold, which you would like to continue. You have a time to consolidate. Another very, very important. please close your NRE accounts or redesignate them. I had a client who made a very, very big mistake because of not very enough guidance, or even the banker was not able to guide. He continued his NRE account for more than 2 years. Unfortunately, uh, the residential status was not non-resident. It was resident and non-ordinary resident. The return which was filed by him didn't capture the interest which he earned in the NRE. He was always resident under FEMA. There was never two doubt about that. He became a resident but non-ordinary resident under income tax because of the special provisions which you have under income tax of the dual conditions which you need to fulfill for becoming a resident and ordinary resident. And till you are non-ordinary resident, you can have your foreign bank account passive income as exempt, but that doesn't mean your NRE income is exempt because NRE income clearly says residential status under FEMA. Hence, it is very, very important to either re-designate those accounts, close those accounts, or be mindful of that this income will become taxable. FCNR, very, very important. Do it before you come back to India. I tell you why. You have two benefits of having FCNR deposits. You get returns in dollar terms and it's exempt. So if I have some clients who come to me and tell, boss, I have, say, let's assume $500,000. I don't need it now, but I will need it over the period of time in India. How should I park that amount to India? I'll say you should take that as long as maturity of FCNR deposits and put that and you want those income tax free. Should always inform your bankers, your companies that you have become a resident in India, your policies, because the menu maturity proceeds which will earn or which will get, or I won't say on, but which will get on the claim has to be repatriated back to India within 7 days of the receipt. Make sure when you move back to India, this is also very, very important. Suppose you were outside India for a very, very long time and you have a lot of assets in terms of your movable assets and everything. It's better to go get that assets back to India within 1 month of arrival to be, exempt from the custom duties, because they'll be part of unaccompanied baggage because you can't bring everything to nice where some furniture or some, cars or something like that. You have to declare your currency if you're bringing more than $10,000. Okay, and so there is a lot of details which you need to be mindful of. Another very, very important thing which you should be mindful of is how you plan your foreign assets, keeping in mind. Let's assume you are into your 40s. You have two kids who are into their teens. You come back to India. You have plans of your kids, being non-residents. Okay. Make sure you plan to keep all those assets in their name, in their outside India, so that they can use for their foreign studies outside India. You can keep that amount in your bank account also. But I have seen people, so let's assume in the case which I gave, that if a person who's returning back to India and if he has some kind of a, I would say assets outside India which you would like to gift. So let's assume, instead of having your kids coming with you in India, you have your kids who are staying in US. You would like to, or US or for that matter, let's assume UAE, and you would like to give the gift of your foreign assets to them. Do that right away. Okay. Because you can't give, as I told you, when you bring that money back to India, you can't give them gifts. It will be part of your $250,000. Of course, you can have that your foreign bank account and transfer later. But the point what I'm trying to bring is that please plan all your gifts well in advance. This is another point I would like to bring to your attention. I hope this session was useful. We have another 5 minutes for question and answers. I'll go through the Q&A. Let me see if I have anything. My daughter has gone to USA in August 2018 for education purpose. She still owns a resident bank account in SBI. I would say, so in your case, your daughter has become a non-resident. Okay. It's better to convert that account in NRO You should not hold a resident account, because in resident account, the type of transactions which you can do are in some transactions are not allowed as a non-resident. So please make sure that that account is being converted to a non-resident account. A father then wants to remit funds to his son outside India who doesn't hold any NRE, NRO account in foreign currency. What permission is required? A father wants to remit a person to, there is no if it is up to $250,000, right? You can directly remit to your son in your foreign bank account. There is a form A2 will be required, and a couple of declarations and nothing else. You can easily remit up to $50,000 to your son outside India. Resident grandmother wants to give 50 lakhs to her NRI grandson. Yes, you can gift. Can she directly transfer from his resident savings account to a bank account? Yes, definitely. What are the implications? Up to $50,000, you can always give gifts overseas to your grandson. You have to fill in Form A2. You have to do a couple of declarations. You might have to do that declaration in your income tax while you're filing your tax returns. If you're filing those, tax returns, if you have income, you should be able to disclose that. For non-resident, if that person is a US, since I know US law, that person has to report in Form 3520 if the remittance, if the gifts are more than $100,000 from overseas. Also be mindful, and this is very important for returning Indians, that if you are coming from countries like US and UK, which has estate duties, if you are a resident of US, you pay your estate duty on a very high amount, which is like 13 million plus as of today. When you exit US, there is something called exit tax, which you need to be mindful of if you have a limit of $2 million. Also, if you are a resident in India and if you have foreign assets in US, there is a very, I would say, minuscule limit for estate for those assets. That's why I would be saying that please be consult with a professional who can guide you on your estate duty implications if you are moving from countries like US and UK, which has good amount of legislations governing the inheritance tax when you move back to India. This is what I would give a piece of advice apart from the FEMA. Many a times, person residing in India acts as a authorized signatory for a corporate bank account outside India. What are liabilities? So see, this is where I will give you a very good example. See, having a signatory is not a problem. Continuing signatory also not a problem if you have control over that account and if you are able to disclose that account in your ITR after you move back to India. But let me give a very good example. I had a client who got a job in UAE. In UAE, you become a license. You have to you have a license, and on license there is a manager. Manager is a authorized signatory for the bank accounts in Germany. That person left the job of that company. He actually resigned as a manager. Unfortunately, that company didn't change the name on the license or didn't change the thing in the bank accounts, which he was not aware of. So he continued, in the year where he knew that he was holding. But after we moved to India, he did not disclose that bank account in his Indian IDR. However, the government got the information that he was holding the signatory in that bank account, and it became a case where he had to fight tooth and nail to say that, boss, I don't have any rights of this account, even though my name is there in those bank accounts. So hence, it is very important to know your liabilities and make sure that you please, when you resign from your employment, you remove your name from all the bank accounts overseas. Another question. LIC policies are being continued by the father for a daughter who is a non-resident, and the maturities are deposited in a bank account in SBI. There is no restrictions. However, again, this income might be tax-free. From Indian perspective, you might have to see whether it is taxable in the foreign jurisdiction. If it is in general tax-free, you should not have any problem. There is no problem in that case. Father remits 2 crores to son in Dubai, uh, assuming it fits in $250,000 annual limit. The same is in his NRE account, on which interest is paid, of course. Can he remit part of such interest back to the father to meet his daily expenses? Yes, it can. Transfer from NRE account to your father's recipient account should be fine, but you need to show that as a gift. Let me know if any other questions. Otherwise, I think thanks a lot for sharing for giving my opportunities, for giving me this opportunity to share my views on the topic. Thanks, Taxman, once again. Thanks everyone who spent their time on a weekday evening, and very, very thanks to everyone.